Hi, I'm Sandy Briggs, and I'm here today to interview Mr. Samuel Behrman, an attorney who has practiced in Pensacola for 33 years. And today we'll talk about negligence claims. Good morning, Mr. Behrman.
Good morning.
What is a tort claim, or more easily referred to as a negligence claim?
A negligence claim is a kind of a tort claim. Tort claims involve other matters as well, but the claims we're most familiar with are negligence claims. An automobile accident is a good example of that, when somebody runs a stop sign and hits somebody else and injures that person. The victim in that case, the one with the injuries, has a claim against the person who ran the stop sign causing injuries. And so the claim can be for medical bills, the claim can be for loss of income, the claim can be for the injuries. The whole concept is to make the person who is injured whole for what happened to him.
We have all heard the word damages. Exactly what are damages?
Damages are the elements sought in a claim based on one's negligence. Let me go back to that automobile accident. The damages are the essence of the claim filed by the person who was injured against the person who caused the accident. And so the damages specifically are medical bills that aren't paid. The damages are lost income that's not paid. The damages also can include the concept of compensation for injuries. It's kind of an unusual concept, but when somebody's injured in an accident, the law can't heal that person. What it can do is compensate that person for pain, anguish, suffering, effect on his life, that type of thing. Those are damages. And right or wrong, the system that we have is financial compensation for those losses. So damages basically in a case like an automobile accident is money to compensate somebody for those elements: medical bills, lost income, injuries.
What are the processes that you follow in terms of a negligence claim?
When a client comes to see me, the first thing we want to do, of course, is get all the information that we can from the client about the accident, about the effect of the accident on the client, all details of the accident. We will then find out what we can about the insurance situation. Typically, the person causing an automobile accident or other types of accidents, it can be a slip and fall, it can be other accidents, not just motor vehicle accidents. But we want to find out about the insurance situation on behalf of the person who caused the accident. So our goal is to get all the information we can about the claim, the damages. Find out lost income, find out medical bills, find out what the essence of the injuries are from the doctor treating the person. Once we have all that information, we try to settle the case. We never file suit right away. We always try to settle the case first. Only if the case can't get settled with the insurance company for the person who caused the accident do we then contemplate filing a lawsuit. And then if we have to file a lawsuit, we file the lawsuit typically in state court and proceed. And that's the procedure that we follow in these cases.
How are you paid for your services? Do clients have to pay a great deal of money up front?
Clients pay nothing up front in cases like this. We take these cases on what's called a contingency fee, and it's called that because whether or not we get paid is contingent upon whether we're successful with the claim. So if we get involved in the case and it turns out that for some reason we can't make a recovery in the case, we don't get paid. There are many cases that we look into, and for one reason or another we decide we can't go forward with it. We put in time, we put case expense into it. We just have to close the file, let the client know that for some reason we can't help the client. Maybe there's no insurance, maybe there was no fault on behalf of the other person, or some other reason. And in that case, we don't go forward with it. We withdraw. We tell the client that we just don't think there's a claim, and we don't get paid anything. On the other hand, if we go forward with the case and we're successful in making a recovery on the claim, And we typically charge a percentage of what we recover, and that comes out of the recovery. So we don't get paid until the process is over and the settlement is made, and at that point we get paid for our services.
Do many of these cases actually go to trial?
That's a good question, because the perception is that that if you file suit, you're going to end up going to trial. That seems to be the perception of a lot of clients. Fact of the matter is that very few cases go to trial. 90+% of the cases that get filed get settled, and even more now than a few years ago, because now we have mediation required in every case, and mediation is a settlement conference. And so it's remarkable that probably less than 5% of lawsuits that are filed go to trial. In criminal cases, more cases go to trial. In civil cases, not very many cases go to trial. Again, probably less than 5%.